Human rights in India, role of judiciary and judicial activism. Human rights can be defined as those rights which are inherent in our nature and without which we cannot live as a human beings. There are claims made by virtue of the fact that we are human beings. The paper deal with human rights in Indian Constitution. The paper is an attempt to analyze the role of judiciary and judicial activism for the protection of rights in India. After independence, India has played a very significant role in the protection of rights. India has not incorporated as elaborate bill of rights in its constitution by effort have been made to translate these realities. Judiciary in India played a crucial role to translate these rights in reality. Introduction. Human rights are basic rights and freedom that belongs to every person in the world. We are all equally admitted to our human rights without discrimination. Injustice anywhere is a threat to justice everywhere. First, human rights are right inherent to all human beings. Right is not merely speaking about biological needs, but also those conditions of life which allows to freely development and uses or human qualities of intelligence and conscience and to satisfy our spiritual needs. Human rights in India, constitutional provisions. India is a democratic country. During our freedom struggle, the freedom leaders of the freedom movement had realized the importance of rights. The Motilal Nehru Committee had demanded a Bill of Rights as far back as in 1928. It was therefore natural that when India became independent and the constitution was being prepared, the concept of human rights was accepted. A unique feature of the Indian constitution is that a large part of human rights are named as fundamental rights. The fundamental rights in the Indian constitution constitute the Magna Carta of the individual liberty and human rights. Second, Indian constitution provides us a list of fundamental rights. First, right to equality. Second, right to freedom. Third, right against exploitation. Fourth, cultural and educational rights. Fifth, right to freedom of religion. Sixth is right to constitutional remedies. Role of judiciary. In our country, judiciary is known as independent part of government. This independent judiciary has two rules. First, the traditional role that is to interpret the laws, and second, judicial activism that is to go beyond the statutes and to exercise the discretionary power to provide the justice. It plays both roles in very well manner for the protection of fundamental rights. Any individual whose fundamental rights have been violated can direct move the Supreme Court for, namely the Supreme Court and High Court can issue writs to the government for the enforcement of rights. Habeas corpus. A writ of habeas corpus means that the court orders that the arrested person should be presented before it. It can be also ordered to set free an arrested person if the manner or grounds of arrest are not lawful or satisfactory. Third, mandamus. Mandamus is a Latin word which means we command. This writ is issued when the court finds that a particular office holder is not doing legal duty and thereby is infringing on the rights of an individual. Prohibition. This writ is issued by a higher court when a lower court has considered a case going beyond its jurisdiction. Quo warranto. The quo warranto literally means by what warrants or what is your authority. If the court finds that a person is holding office but is not entitled to hold that office, it issue the writ and restricts that person from acting as an officer holder. Certiorari. Under this writ, the court orders a lower court or another authority to transfer a matter pending before it to the higher authority or a court. Thus, judiciary plays an important role for the protection of our fundamental rights. Judicial activism in India. The term judicial activism was coined for the first time by Arthur C. Singer Jr. in his article, The Supreme Court 1947, published in Fortune magazine in the same year. Through the history of judicial activism date back to 1803, when concept of judicial review was evolved by Chief Justice Marshall in celebrated cases of Marbury versus Madison. The emergence of judicial review gave birth to a new movement which is known as judicial activism. Definition: Black Law Dictionary. Judicial activism as a philosophy of judicial decision making whereby judges allows their personal views about public policy among other factors to guide their decision. Exercise of unconventional jurisprudence or creative approach of judiciary can be called as judicial activism. For instances, in India, the Supreme Court has treated even a letter as a writ petition and has passed appropriate orders. This concept has turned into an important means to enhance the applicability of a particular legislation for social betterment and also to bringing improvement in the concerned state machinery.